You're not going to go home today. Okay. If I continue you on probation, which you don't want a felony conviction. At this age, it changes your life in a very negative way, but you obviously need some, in my opinion, just a little more help to make better decisions. And so what I'm going to do is find that you entered your pleas of true to counts 1 through 10 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and send you to prison. I'm not going to do that today. I'm going to continue you on probation, but I am going to order that you now enter and successfully complete the cognitive track of the ISF program. So you went to the substance abuse track so that you could get tools to stay clean. This track helps you make better decisions, helps you grow up. It's hard at 19 to make the decisions that you need to make to be able to stay on this probation, and this is meant to help you. And so you'll go from jail to that program, you'll get out, you're still going to be on probation. You will be on zero tolerance probation. That means if you make another mistake, Ms. Lopez is going to send something over, there's going to be another motion. I'm going to look back at this. Mr. Coleman and Mr. Smith are going to remind me that they asked for prison time this time, and it's probably not going to be the 3 years. Do you understand?
Yes,
I hope you take advantage of this opportunity. All right. Good luck to you, ma'am. You can go back with the bailiff. Come back for a second, Alan.
yes, ma'am.
And this is 23 DCCR 0639. Miss Allen was placed on probation October of 2023 for evading arrest or detention with the use of a vehicle. In court, previously entered pleas of true and a motion to revoke probation to counts 1 through 10. I've received that updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections to that report?
None that I'm aware of, Judge.
Not from the state, Judge.
And this is unagreed. Mr.
Correct.
Parker, you may proceed.
Your Honor, all I can say is, these violations are all technical, even though, I understand that they're still serious and you have to follow the rules of probation. She's young. She's 19 years old. I think being in jail has opened her eyes, and she wants to complete probation. She has quite a bit of time behind this, and my deal was, take the time. She said, I don't want to do it. And she's sincere. She says, I want to prove to myself and prove to everybody else that I can complete this probation. And she has the opportunity. She has a job waiting for her. She gets out, and she's requesting this probation, and she'd like to address it for the judge.
Go ahead, ma'am.
I just want to say I own up to all my wrongdoings. I do. I know it was wrong. I knew it was wrong when I was doing it, and I regret it, but I want to prove that I can do better, and I'm not the person that I have to be. I'm young. I want to build my relationship back up with my people, make it stronger, build my trust. Just do the right thing, make it right before it's too late.
Thank you, ma'am. Mr. Coleman?
Your Honor, this is Mr. Smith's case. I'm under the understanding that Mr. Smith made a 3-year offer in this case. I am cognizant of the fact that recommendations from probation department on the last page states that while the defendant's violations are mainly technical in nature, this officer is not inclined to recommend continuation of supervision at this time. So with that, my position is the same as Mr. Smith's, that should be revoked from some jail time.
Ms. Lopez, do you have anything to add other than what's in the update? So, Ms. Allen, the only thing that I'm inclined to do if I continue, you are young. You don't have a lot of criminal history. This is your first felony, no misdemeanors. Of course, you're young, but you were actually certified as an adult for this, which is, I don't know, certifying on an evading is a little, I guess it's because she was so close to age, but still, So here's the thing.
Yeah.
Well, I just want to make sure of something else. I want to make sure you understand something else. That if you get incident reports in our jail or in ISF, that will be a violation of your probation. And you may not ever make it to ISF. So if you are you're going to say things to the correctional officers, not do what they say, and tell them that you don't care about getting a write-up, but say those things in a lot worse ways, then you're going to go to prison. And you're not going to go to prison for 3 years. They're just there doing their jobs. If you follow the rules, they'll probably leave you alone. If not, their job is to make you follow the rules. And if you can't follow the rules in our jail, then I don't assume that you can follow the rules on probation, which you're kind of showing a pattern here. So it's time to grow up, change all that. Is it going to show up here? It says it was.
Let me show you. This is what he filed in the original case, and then they re-indicted the case in the bond, switched over to that one.
So can we get this to show up now in the original? I mean, in the new case?
I can ask him to either redo it, or yes, ma'am, I can get it in there.
Okay.
I will do that.
Okay, let's see. You are Gabrielle Smith. Stand up, please. And this is cause number 25, DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct? Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the other one? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now for trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
And guess what? Just here. Ready to get my charges, I guess, decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Two, three, yeah, but 2, 3 Ds or 1030.
Like, such a big crock, I've done that all by myself.
Every time something happens,
So it looks like okay, there was back in February of 2024, there was a bond forfeiture. And so the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
she did enter a plea, Your Honor.
Entered-
It's a PSI bond.
I did
That
at
plea was
one.
Rejected by the court.
Okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess. Or-
for a PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out.
What goodness. Sufficient.
Okay. And then let's see. Let me look at this PSI. That'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000. So I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report,
Court revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you were rejecting that.
right, and several misdemeanor thefts and a revocation, into prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at 40,000 on a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. Involved a vehicle. I think the officer had leaned into it and then the vehicle went into motion. And,
Well, how did the vehicle go into motion?
well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
He scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about, I suppose.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got a speedy trial, I guess, so we get it tried.
And in the 252nd, everything's speedy.
All right.
It will be placed, I mean, is it, it wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
Well,
the,
I guess if the court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
You can take 8.
Take 8. You want me to do a rejection?
And still be
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Goodness gracious. Mr. Matuska, you've got Xavier Garner,
Yes, Your Honor.
6 cases. Oh, I don't have, hold on, let me recall that in just a second. Do you have some stuff coming through on Garner? I've got a registration, but I don't have anything else. All right.
And then I'll need to tell the judge up in the computer.
Okay, that's okay. I'll hold it for just a second. Thank you. That's gonna be a good one. Get rid of 6 cases. Mr. Parker, you've got Jacoby Judge.
Can't remember what I've done on
No, I just looked up and I've got a line of things ready, which is good. Yeah. Good morning. Are you Jacoby Judge?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Judge, in cause number 24 DCCR 1174, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 17th of 2024 for the offense of obstruction or retaliation, a 3rd-degree felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to provide verification of attending the SafeP program. Is that true or not true?
True.
And then count 2 alleges that you failed to successfully complete the SafeP program. Good grief. These are a mess.
I don't know why they phrase them like that, Judge. I mean,
All right.
He did it twice.
Okay.
But
You didn't complete the SafeP, you didn't complete the SafeP program, right?
No.
Okay. Did you enter your pleas of true to counts 1 and 2 freely and
Yes,
voluntarily?
ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
no
1.
objection?
It's admitted. Is there any evidence that Mr. Judge is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes.
Right? Good luck to you, sir. You can go back with the bailiff.
It's on there. It's not real now.
Warren Mills,
Judge, I'm
Mr.
going to ask that, we reset that a couple weeks. We've had issues with the video. I've got the video and I need to go with him. He wants to talk to his
Okay.
family.
All right. We'll just do maybe about 3 weeks on
That's fine.
Mills.
Third Street, I believe.
Shaniqua Washington.
Bertrand, Delaney.
Morning.
Shaniqua.
Good morning. Are you Shaniqua Washington?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Washington, in cause number 24, DCCR 2370, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from September 29th of 2024. The indictment alleges you were previously convicted of theft April 7th of 2010, and then again July 12th of 2012. And how do you plead to that charge?
Yes, ma'am.
And are those two prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with? Did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a deferred probation. How long?
3 years.
I'm sorry. Can y'all, any problem with me writing that in?
I wrote it. Well, maybe
didn't-
she
it didn't
probably
come
sent
through.
She sent it before.
3 years. Okay, so a 3-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Is there any restitution or were the items
They were recovered.
recovered? Okay. Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Ms. Washington's not
No,
competent?
Your Honor.
Other than those 2 that are listed, do you see other issues? or-
Judge, I see nothing but misdemeanors, so she's got misdemeanor history.
Okay,
We're asking waive the DSI.
We're okay with waiving it, or if the court wants one, we're okay with a PR bond.
yeah. I mean, if yours,
There is
This-
history.
there is, I mean, the last one that's listed here is 2012,
We've got some other charges other than.
That's misdemeanor.
other than deaths.
Yeah.
Okay, all right, then I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Did I print that? Do I need to do it again? I might not have. Okay, going to find sufficient evidence, find that you entered your plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. That shows this was an agreement that I followed, so you waived your right to appeal. Probation's going to talk to you before you leave today. It's very important that as soon as you get out, you do everything that they're tell you to do, okay? All right, good luck to you, ma'am. Let's see, Kendrick Williams, 4 cases are called, Mr. Parker.
Kendrick Williams.
Your cases are gonna be on there, but whatever on this day, just say, just ignore it, you don't know if you're working on it right now.
Okay, so we've
I
got,
didn't write CC on these cases, Judge, but
okay. That's fine. And are we going on, are there more than one count? Are we going on?
On the
I
motion,
did
Your Honor,
second degree.
No, are they all
Well, the
new
state jail
cases?
that's enhanced and
the state jail requires its enhancements.
That's the possession?
Yes, sir.
I-
Well, there's two
I'm-
possessions, Your
I'm
Honor.
thinking about it.
No, the evading arrest and previous convictions.
I'm just now thinking I may have filled out the state jail paperwork wrong. I'm not positive, but I may have.
Just be patient with me as I pull it and then I'll
No.
figure out what we need to do, if anything. Okay. Are you Kendrick Williams?
Yes, ma'am.
And will your client waive the formal reading of the indictments and also the motion?
He will, Your Honor.
Okay, so there are priors listed, so it is count one. I'm assuming,
Yes, Your Honor.
at least on the 1075.
But it's not needed. 1075 or 2352.
Okay, just 1076 today.
Yes, Your Honor.
Okay. In cause number 24, DCCR 1075, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of possession of a controlled substance from February 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? Give me just a second. In cause number 24, DCCR 1076, you're charged with a state jail felony offense of evading arrest or detention with previous convictions. And is he getting state jail time on
No,
this?
that's what I think. I
So we
filled it.
need all of them.
Yes.
Did you do state jail paperwork?
I don't remember. I'm thinking I've had in state jail paperwork. I've got this one up here. I've redone it. I just don't remember if I did or not.
Okay. So the offense date on this is from February 19th of 2024. The indictment alleges you were previously convicted of evading arrest or detention September 26th of 2007. It further alleges that you were previously convicted of possession of a controlled substance, a state jail felony, September 24th of 2007, and also possession of a controlled substance, a state jail felony, September 4th of 2012. And how do you plead to that charge?
Guilty.
And are all of those prior offenses convictions true?
Yes, ma'am.
Okay, let me make that note real quick. This is so much better than paper. Okay, and then in cause number 24, DCCR 2352, you're charged with the second-degree felony offense of injury to a child, elderly, or disabled individual from July 19th of 2024. So that's already a second. Are we going on the other counts as well,
We
or
don't
no?
need to, Your Honor, just count one.
So in that count one only, how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? In all three of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes,
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in those 3 cases.
No objection, Judge.
It's admitted in each of those cases. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in cause number 24 DCCR 1075, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You did it right.
I did?
Mhm.
Okay.
In cause number 24, DCCR 1076, I'm also going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And in that case, find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2352, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, let me get the MTRP pulled up.
And Judge, counts 1 and 2 include some of the cases we just pled to. The third one was not yet added as an amendment, but since we had an agreement, we just go on 1 and 2.
1 and 2, okay. All right, in cause number 21, 36841, I have a motion to revoke your community supervision. It shows that you were placed on probation October 13th of 2021 for the offense of assault on a peace officer. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense that we've already talked about of evading arrest or detention with previous convictions, February 19th of 2024. And is that true or not true?
Yes, ma'am. Sure.
And then count 2 alleges that you committed the offense of possession of a controlled substance, February 19th of 2024. And is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I also have here on the computer in that case some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these papers with Mr. Parker?
Yes, ma'am.
And do you fully understand them also? And you understand if I follow this agreement, you will be waiving your right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all. What you need? Y'all need some? Yeah, I can just give me this.
Yeah, he don't, new cases, I didn't.
Okay. Bailiffs already know. Okay.
Damn.
It's reset if he's here. Just.
Amanda Arendt.
Judge, that's, the state is asking that we reset that. This is Ms. Maltino's case. She's trying to talk to somebody about, I don't know, to give me an offer.
Okay,
She's asked us to reset.
we'll just do one normal reset on that. Kyla Allen, it's a sentencing, Mr. Parker.
Yes, Your Honor. What I do? No, she can go back. I told you already. Kyla Allen. For sure. So, oh, you gotta get their level of argument, you know. It's
All right, ma'am, are you Kyla, or you're going to prison? It's that simple. Understand? Okay, go back with the bailiff. I don't know how I did that. Okay. Bobby Clark, Mr. Parker.
rejection. Cheers. It's rejection. My wife's been home 24 hours in 4 weeks. She sent a text to one of our friends. I don't know when I'm coming back to New York. She's serious. She's serious.
You're like, hello?
I mean, being a bachelor's not easy. I'm telling you.
You're
I'm
gonna have
not
to,
very good at sitting at home by myself.
Yeah.
I have to go out.
that's not a good thing either.
No.
Good morning. Are you Bobby Clark? Speak up, please.
Yes, ma'am.
And Mr. Clark, in cause number 25, DCCR 0802, you're charged with a second-degree felony offense of indecency with a child by sexual contact from March 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? Speak up.
Hold just a second, Judge. Yeah, this is what I'm,
Oh,
well,
I screwed up, Judge.
4 is 12.
He had 4 here. It's 12 years, and I didn't, well, I'm assuming you're going to want to reject that.
Okay, so
But I didn't know.
I was wondering.
Yeah,
Make
you
sure,
had-
no.
that makes sense. I was telling him, I think it's a very good offer.
It was, yeah.
Yeah.
That was, apparently, that was his old case, and I didn't see down below where he.
Okay,
I didn't
so
see the bold,
so Mr. Clark, the offer in your case is actually
12.
12 years. And I'm assuming since you wanted to reject the 4 that you want to reject the 12. Is that correct?
Yes, ma'am.
And so again, I just want to make sure you understand the possible consequences if you go to trial and are found guilty. The punishment ranges between 2 and 20. The option right now is for a 12-year term in prison if you wanted to plead guilty. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, I will get that done. Is there any reason to believe that that offer would change? So I want to make sure also you understand that after today, unless there's some new information that comes up that the lawyers don't know about, I will not accept this plea agreement. You understand? Speak up, please.
Yes, ma'am.
Okay. And so, Mr. Clark, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who can begin preparation for trial a little quicker. Is that okay with you? So, Mr. Parker, you're released. Mr. Clark, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you go back with the bailiff.
Thank you.
Mr. Matuska, Vonzell Hall. Morning. You working on the other one? Are you doing paperwork on Garner still? Huh?
We've got it, Judge.
Oh, you've already done it?
Yes, ma'am.
Okay, I see. All right, perfect. Vonzell Hall.
I missed the opportunity to tell you, I told you so earlier. I really regret it.
Did you?
It was a cap and they got permission and we left them today. Meant to.
You should, you got to take advantage of those
I know, that's
opportunities.
it.
I give them to y'all, so.
But it also was kind of like Priscilla, maybe Ashley wasn't mad, so I didn't tell you, so. I really shouldn't claim it.
It's okay. You're here for her. Good morning. Are you Vonzell Hall?
Yes, ma'am.
And Mr. Hall is charged with the offense of murder in cause number 24, DCCR 1747. And what is the announcement?
Your Honor, we've received a plea bargain offer, and that we've been unable to reach an agreement on that offer.
Okay.
And I've informed Mr. Hall of that offer today. It actually has come down a bit, but I've updated him on that. Again, we haven't been able to come to an agreement.
Okay.
And I see no reason why it would come down any further, Your Honor.
Is that a new rejection that
Yes,
you
Your
have? Okay. If y'all will sign that so I can get it over here and that way I have that. What's the offer?
It's 35 years.
So, Mr. Hall, if you don't want to take that offer of 35 years and you want your case to go to trial and let a jury decide, sign that document real quick and then we'll get it set for trial.
And Your Honor, this is not a cap. This is straight.
Okay. Well, your options are to take 35 years in prison or to go to trial.
So if I sign this, I'm accepting it?
No, if you sign that, that's the rejection that says you want to go to trial, that you don't want the 35 years. If you want to plead guilty and take the agreement for 35 years, there's some different paperwork y'all can do this morning and we'll get that taken care of. But if you don't want to take that offer, then we'll let a jury decide.
And I don't know if it's on that rejection, but I did discuss a possible 40-year cap with Mr. Matuska. If he wants to talk about that.
Do you want to talk?
I told you that.
So either you want to take the 35, take a 40-year cap and let me decide. I could give you 40, I could give you less, or let a jury decide if you're guilty and what your punishment is. That's your options.
You want to reject that or discuss
Take a 40-year cap.
it? Okay. Well,
Yeah, I'll go do that paperwork. I'll hold it for the paperwork then. So I'll delete this. Oh, wait, there wasn't anything. You can
No, they
delete it
hadn't
on your,
sent it
y'all
to me
hadn't
yet,
sent it
Judge,
yet.
so-
Okay, I'll hold it then. Let me, well, Mr. Matuska, I'll let you take care of that and then I'll do Garner in that one when you're finished. Get you all taken care of. Let's see. Ms. Holmes. I don't, oh, did he? Let's see. What was that on? Gabriel Smith. It's here. Mr. Kimler on Gabriel Smith. Gabriel Smith.
I think that's one we did.
I know, I need to do the rejection.
Oh,
Yes, please, ma'am. Okay, again, you're Gabrielle Smith. And Ms. Smith, in cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Moffitt, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here. If any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have two sequenced, it would make you habitual. Do you understand?
if she has one, it would boost her up to a first.
Yes, sorry. So if you have
I'm
one.
still not understanding what they mean.
Okay, so listen very carefully. You have several felony convictions out of Louisiana.
Mhm.
Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life if there's one prior conviction. You understand?
Mhm.
Answer out loud. So
Yes, ma'am.
okay. If there's two prior felony convictions that happened, not all of the, I know there were several that happened at the same time,
Mhm.
right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are two that happened at different times, then it means you could be considered a habitual offender here in Texas.
Mhm.
And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count one, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years and what your possible consequences are if you go to trial. Do you understand all of that?
Same.
Okay, and do you want to reject that offer and have your case set for trial?
Yeah, I want to reject.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes to trial. So it's not, we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I haven't, so I can't think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for.
You have to decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If y'all do it again, you'll have to do it again. Okay? All of her, if you want to see that old PSI, it's got all those listed. We could get you a copy at least of that page, I'm sure.
I had a real question on, with Louisiana, felonies and the judgments. Sometimes the judgments are problematic for Louisiana. It depends on which parish.
Okay. Well, y'all figure that out. Do you need more time than a
No,
week?
ma'am, that's fine.
Ms. Holmes, you're sitting over there so quiet in the corner. I didn't even see you. You've got LaKendris Addison.
Yeah.
Good morning. Let's see, this
Judge,
is a motion.
We have an agreement on this case.
Okay.
On count one, I'm going to drop January 2022, February 2022.
Hold on half a second.
Oh,
Let me
sorry,
get that pulled up so I can make this. Okay. Count one.
And if it's okay with the court, we can proceed just on count one. But I was going to drop the January of 2022 and February 2022. He was taken into custody in Louisiana during that time, Your Honor.
Okay, gotcha. Okay. Good morning. Are you LaKendris Addison? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will.
I'm sorry, the motion.
Yes, yes, ma'am.
Mr. Addison, in cause number 21-36633, I have a motion to revoke your community supervision. Shows that you were placed on probation September 15th of 2021 for the offense of burglary of a habitation. And that was a 10-year term that was suspended and you were placed on probation for 10 years. Is that correct? And then count one alleges that you violated your probation and the state has amended that. Count one alleges that you failed to report as directed to the probation department October 5th, November 3rd, and December 2nd of 2021. And is that true or not true? True or not true? Count two alleges that, oh, I'm sorry, you going
If
on
it's
just
all-
count one?
We can, Your Honor. if it's
Okay.
Okay with you.
State abandons 2 through 5. Did you enter your plea of true to count one freely and voluntarily? And because it's actually true. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Addison is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Let's see. I gotta figure out how to do, the other day I figured out how to do a strike through. I gotta figure out how to do that again.
Ma'am.
Toy Hill.
Your Honor. Taking 35 miles of cash.
Toy.
Mhm. Good morning. Are you Toy Hill? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hill, in cause number 25 DCCR 0650, you're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation from January 24th of 2025. And how do you plead to that charge?
Guilty.
January, did I say February?
You said January 20.
January 24th, 2025.
Yeah.
Is that, are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
I
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hill is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position based on the nature of the plea agreement with regard to bond reduction?
Just for the court's information, I show a criminal history that includes a 4-year deferred on an injury to a child and a simultaneous violation of a protective order for 1-year probation, and assault, which was a misdemeanor, for resisting, and a theft, misdemeanor. I would have some concerns about.
What is your relationship now with Cheryl Johnson?
That's her mother. It's real good.
Okay, so let me ask you this. if you are released, when you're released from custody, where will you live?
With a friend of mine, her name is Tanya, 4555 Reed Road.
Reed?
Reed, R-E-E-D.
Uh-huh. And where's that? What city?
Off of
And that brings this courtroom battle to a powerful close. Judge Raquel West made one thing absolutely clear. The court's orders are not suggestions, and repeated violations can have serious consequences. Her warning to the defendant was simple: follow the rules, take the conditions seriously, and prove that you can stay on the right path. Because once Judge Raquel West gives a final warning, the next mistake could carry a much heavier price. This wasn't just a courtroom lecture. It was a final opportunity to change course before the consequences become permanent. What do you think? Was Judge Raquel West right to draw the line here?